All right, everybody, let's call the calendar. So today's July 21st, it's 9:10. This is the civil non-jury calendar. We have 3 items on the calendar today. Let me see I got a little bit of feedback. I'm just gonna, hey, I tell you what, for you two who are virtual, I'm gonna mute y'all both. Just, you can hit the space bar if you want to just unmute while you're talking, or you can unmute yourself when it's time, but one of you has a little bit of feedback. And so I'm just going to mute y'all to keep that from running over the courtroom. Okay, first case on the calendar. What I'm looking for is who's here and what do we need to do, and most important of all, do you want it taken down by Miss Kathy, the court reporter, and are you going to split it? So the first case on the calendar is no, 22 SV 158. I realized that the case number did not make it onto the calendar. So 22 SV 158 LVNV. So Lima Victor November Victor Funding LLC versus Tina Moore. Anybody here on that case? Okay, so nobody's here on that one. Okay. All right. Well, what I'm going to do on that one is that is a traverse against a garnishment. Nobody's here on that case either way. And so the traverse is, the defendant's traverse is denied. All right, well, let's shoot an order on that. All right, 22 SB 194, Harold versus Pemberton.
Yes, good morning, Your Honor. Michelle Billers for the defendant.
All right, and anybody here for the plaintiff on that one?
Yes, John Paul Bernache for the plaintiff, India Herald.
Okay. Yeah, y'all were the ones with the mediation yesterday, correct?
Correct.
Correct.
We were unable to get it settled.
Okay. All right. Well, then let me make a quick note here. I'm going to call this last case and then obviously come back to y'all quickly. All right. Anybody here on 22 SP 263 Ogletree versus Wellstar? Okay. I have an empty courtroom and only 2 attorneys virtually. Let me go off record. All right, we finished our housekeeping on the other cases, which leaves us with just 226194. All right, I have down that I need to discuss with you all ooh, that feedback's tough.
And I don't know if they answered them, take down.
Oh, yeah. Did y'all want this taken down?
I don't believe it's necessary.
I do, Judge.
Okay. In that case, do you want us to put the takedown?
Well,
Yeah, we can split it.
okay.
All right, then there it is. All right, y'all will be getting an email from Ms. Kathy. And again, if the feedback gets overwhelming, I'll mute y'all and figure out which one of you it is. Right now, it's just a little bit of a background echo. No, actually, it's not. It's when I start talking. Hold on, I think I have an idea of who it is. Hold on. Mute y'all one at a time. All right, I'm going to see if that's it. Okay, Mr. Bronash, it's you. So if you have like maybe some earbuds you could use, that will usually fix it. I don't know what causes it. I just know that from my end, earbuds will usually get that corrected. Do you happen to have any that you might could plug in?
I do not, Your Honor.
Okay. Then what I'll do is just have you mute yourself and then use the space bar to talk. And that should usually, because it's me that causes the feedback when I'm talking. So if you're muted, it shouldn't cause the feedback. So yeah, so you've muted yourself and the feedback is gone. So, okay, well this is not the first time we've had to do this. So it's okay. We have multiple ways to do this. So I'm gonna leave you muted, hit the space bar when you talk. It'll unmute you. I'll stop talking. And then it should be okay.
Okay.
All right, so, all right, who wants to go first and fill me in on what y'all are looking for? I know what I'm looking for.
I can start.
Okay?
So we currently have cross motions, and the kind of the heart of the issue is whether the defendant, Christopher Pemberton, should be compelled to sit for a discovery deposition in this case. Counsel has a motion to compel pending, and I have a motion for protective order to keep him from having to sit for that. Plaintiff's deposition was completed several months ago, and this is an admitted negligence accident. We admitted negligence in our answer, so that's not an issue. It's a rear end accident, no airbag deployment. Both cars were drivable from the scene. Police responded and spoke with the plaintiff. So my argument is, as far as negligence goes, that's not an issue that Mr. Pemberton would have anything to say on, because it's already been admitted by the defense. So the dispute in this case is injury, causation, and damages, all of which he would not have information on. The reason that I don't believe he can sit for a deposition, and I'll tell you in hundreds of cases, this is the only time I've ever asked for a defendant to not have to sit for a deposition. His family early on in this case brought to my attention that he's recently been diagnosed with some very severe cognitive issues. And I outline it in my motion. I've got a document to share. I'm going to attempt to share my screen, Judge, if you're able to see it. So it says I need to be.
That should work. If it doesn't,
Okay. So
tell
it
me.
says you need to make me a presenter. Do you know how to do
Yes,
that?
I do.
Okay. Okay.
Let's go off record a second. Let me set that up.
Sure.
I have this thing set up for my criminal arraignment days, and it's no surprise to you all that my criminal arraignment defendants like to do put all kinds of crazy things up on the screen. We're lucky if they're wearing shirts, not driving, and not smoking. So, all right, let me set this up for you to be a presenter. Or actually, I just need to allow you to share your screen. So give me just a second.
Okay.
Oh man, I was just looking at this yesterday. Y'all be patient with me. I looked at this yesterday in case this came up, and I forgot how to change that setting. Give me just a second.
No worries.
There's been an update since the last time I sat the bench, and I've also got, you'll get a kick out of the fact that I have closed captioning now running across my screen of what I'm saying, and it's a little disorienting. It's odd. All right, let's see if
Okay.
that works.
Okay, I think this is working.
Perfect, it's up.
Okay. And counsel, can you see it too?
You should.
Okay.
Yes.
Okay. So, and the family has an attorney who's working to try to establish a guardianship or conservatorship over Christopher Pemberton. So they shared this with me. This is an affidavit from his treating psychiatrist. Scrolling down, it's this Dr. Taiwo out of Fayetteville. And essentially, this is an affidavit swearing that his treating psychiatrist has found him to be incapacitated by reason of dementia, lacks sufficient capacity to make or communicate significant responsible decisions concerning his health and safety. He cannot make responsible decisions concerning the management of his property. And then if both can read it, I'll let y'all just read the psychiatrist's description there of what's going on cognitively with Mr. Pemberton.
I can read it.
Okay. So essentially saying he requires 24/7 care and cannot be left alone. He was, and I've got a record I can show of this too, but as an officer of the court, I would just say for 2 weeks during January of 2023, he was hospitalized inpatient at Summit Ridge, and is actively treating with this Dr. Taiwo, the psychiatrist. Is on numerous medications. And as far as this description goes from his treating psychiatrist, I have grave concerns for his ability to conduct himself during a deposition, appear for a deposition, and give any kind of meaningful testimony regarding anything involving the accident, particularly when negligence is not in dispute here. I think the only potentially complicating factor is that plaintiff in this case is, per her complaint, alleging a hit and run. And in my motion, I laid out, and in my response to plaintiff's motion to compel, I addressed this. But um, between plaintiff's own deposition testimony and her response to my request for admission on this subject, I think there's no question that this is not going to rise to the level of punitive damages based on a hit and run. So essentially, Miss Harold admits that my client stopped, that he exited his vehicle on the scene. He gave her his Georgia driver's license, his correct license, and let her take a picture of it. The license had his full name and his correct address. That he allowed her to take a photo of his vehicle's license plate that he was driving, um, and that she did not report any injury to him and did not request any medical attention on the scene from him, and didn't mention anything about any pain or injuries to him before he left. And she testified that he said, I have to go to work, I got to go. And that's what happened. She said she didn't physically try to stop him, she just didn't say anything. So, or I think she said something, her testimony was, she said something like, "You're stupid," or something like that. So the main issue and her main complaint is that the insurance card that Mr. Pemberton showed to her on the scene and that she took a picture of was for his own vehicle. And so it said Christopher Pemberton, it had State Farm insurance, but it was for a truck of his. Whereas at the time of the accident, he was driving his mother's vehicle. And Miss Harold testified she didn't have any reason to believe that that mistake was intentional. And again, the card he showed her had his correct insurance company and his full name on it. So we don't have any reason to think that he was trying to evade or hide. So I really don't think, I'm waiting on this issue to be decided by Your Honor as far as the deposition goes before filing for summary judgment. But I think based on the case law for punitive damages based on a hit and run, we would have summary judgment on the issue. So that's my position. I don't believe there's any probative value in Mr. Pemberton sitting for a deposition. Based on his own psychiatrist's affidavit, I have concerns about his safety, his ability to communicate, and to provide any kind of probative, meaningful testimony in this case. And I really don't know why they want his testimony, to be honest. So,
Okay.
so we're asking that the court, we're asking that you enter a protective order saying he does not need to sit for a discovery deposition.
All right, a couple of quick questions before I pivot over. Have you all cleared up the insurance issue? You've given them the correct insurance information now regarding the vehicle?
Yes, and there's no issue of coverage. That's not an issue.
Okay, I just want to make sure that was clear on the record, that that has been
Yes.
cleared up. And then as far as the hit and run, I understand your contention, and we'll address that when we get to it. At this point, I'll just take that as context for the issue. Do you have the ability, when you sit down with your client, to, even if it takes a while, be able to have a conversation with him? It's kind of like an analogy I'm thinking of in my head is like, let's say that, interpreters, lots of people come in here who need interpreters. But there's different ranges. And so some people, if you sit quietly with them face to face, talk slowly and repeat yourself often, they can get it in a private one-on-one setting, but would not be able to even dream of doing it in a public plea or courtroom setting. Do you see the difference? And I'm trying to understand the level of his dementia. Can you elaborate on that and give me that scale?
Right. I will just say, and again, it's getting into attorney-client type communications, but I realize that I'm raising the issue by making this argument. But I will say I have not had meaningful conversations with him about the accident. I've had numerous conversations with his mother and his adult sister, and I have grave concerns about his ability to conduct himself during a deposition. Whether he's giving it from home, whether it be giving it in counsel's office, which is an option. I'm very concerned about that.
Do you have a proposal for something short of a deposition that could provide the other side with the information that they need, such as interrogatories, requests for
So-
admissions.
So we've answered interrogatories. I believe I answered requests for admissions early on in this case with the information I had, which was, limited what I've been given. I will state too, and this is probably important, I don't expect to have Mr. Pemberton with me at trial. So I get that might be unfair to have him in the courtroom, but then say, oh, but you can't ask him any questions. That's not what I intend. I don't intend to have him in the courtroom with me at trial. So that's that.
All right, those were my follow-up questions.
Yeah.
All right, Mr. Bernash, the floor is yours. Oh, you're muted. Hit the space bar.
All right, can everybody hear me?
Yes.
Okay. So that's the first I've seen, Your Honor, of that affidavit. And I understand, if he really does have this dementia, that is one thing. On the plaintiff side, is this more so the timing of the dementia coming to the forefront as an issue? This this case was filed about a year and a week ago. So I believe July 14th of 2022, this case was filed. His deposition was scheduled for March 1st of this year, 2023. As we saw with the affidavit, that was signed by the doctor, I believe, at the end of March. The defense protective order was filed, I think, 4 days before the deposition. And as the defense counsel said, and when she had the floor, he was employed at the time of the accident. So we have the man employed. We believe he fled the scene early, and now 4 days before his deposition, he's incompetent. So for us, it's just the timing of the issue. He was the driver who hit our client, and she has suffered, real injuries that she's dealing with daily. And his testimony is relevant and material to our client's case being presented to a jury. So we believe, he should. I haven't talked to the defendant, so I don't know what capacity he's in, but I believe he should be forced to sit for his deposition at this point in time.
All right, so my follow-up questions for you is, if I were to, and I'm just throwing out ideas here as I'm trying to frame up a solution for y'all. Is there any way this could be divided into like a phase 1, phase 2 for you, such as, you send over written questions to opposing counsel for the things that you need answers on, such as interrogatories, additional requests for admissions, that kind of thing, that could get those answers for you without forcing him to sit? Or is it your goal to be able to show what he can and cannot answer in person? Does that make sense, what I'm trying to figure out?
Yes, Your Honor, and it's the latter.
Okay. All right, so then in discussing that question, because I understand your need, do you have a proposal for how this could be done in a way that is respectful to his condition, but at the same time provide some sort of safety net or steam vent or something where, this thing could very easily be at the point where somebody has the right to say, okay, this is not going to work. So let's say we get everybody down and you start asking questions. I'm sure you would not do this, but it's my job to think worst case scenario and plan it. If I were to have him sit down and, you were to ask him questions for an hour and he answers none of those, that to me doesn't seem very reasonable. And I'm not saying you would do that, but you see what I'm trying to get at? Like, if I were to have him sit down, how could I know without being there that only a reasonable amount of questions would be asked before everybody looks at each other and goes, yeah, this is a no, it's not going to work?
Plaintiffs would be okay if he had a significant other sit in on the deposition and perhaps help him where he needed help. That is that's a solution the plaintiffs would be fine with doing.
Well, what happens if, I don't know, let's say, I mean, folks with dementia sometimes get agitated. What happens if he starts to get agitated and the family members and Ms. Billers are both sitting there thinking, we gotta cut this loose and you wanna keep it? And obviously, you see the issue, I'm not there, not like at this moment. So how does that moment get resolved without me sitting at the table?
I understand, Your Honor. So if it gets to that point where, it's hostile and uh he's, demonstrating frustration, we'll just suspend the deposition. I'm not trying to, put this man through anything that could worsen his health. I'm just simply trying to gather information and discovery. So if it gets to that point, I will have no problem stopping it, say, okay, that's clearly enough. I'm not trying to push him to his brink to, answer these questions. So
Judge,
yeah, that's
I'd
not a
like to
problem.
I'd like to interject, Judge, because I'm concerned about where this is going.
No. All I'm
I
doing, Ms. Billers, just take a deep breath. All I'm doing at
Yeah.
this point is exploring both sides' questions to their logical conclusions. So
Okay.
don't panic. I do not have a way I'm going in this. I went in
Okay.
your direction all the way as far as I could take yours, and now I'm taking his as far as I can take his. So don't panic. Let it finish though, but I do want to hear from you. All right, go ahead, Mr. Fernand.
Yes, Your Honor, thank you. Now, I was just saying, if it gets to that point, we will most definitely suspend the deposition. I'm not trying to, worsen that man's, the defendant's health by having him answer something and him being unable to answer and causing worse damage for his health. That is completely fine. If it comes to that, that is not a problem. But we would like to get the chance to ask him questions via deposition.
Okay. All right. Anything else before I pivot back to Ms. Billers? Okay. All right. So we'll pivot back. And again, hear me say very clearly, I do not have an inclination on this. I'm just trying to explore both of your positions to their logical conclusion. And then I'm gonna take this under advisement. I think y'all figured this out. And I'm gonna be issuing an order on this. All right. Floor is yours, Ms. Billers.
Okay. So I've not heard what probative value counsel thinks could be gleaned from taking a discovery deposition of Mr. Pemberton beyond what has already been admitted in discovery, admitted in his client's deposition, or admitted by us in our answer. I think what counsel said was that he's interested to see what questions Mr. Pemberton can't answer. That in no way is probative of whether his client was injured in this accident, to what extent she was injured, and whether her treatment was reasonable and necessary. She herself testified that she never told him she was injured, never made any pain complaints to him on the scene, and that she wasn't bleeding or visibly injured. She said that. So there's nothing more Mr. Pemberton could add on that point. I think if you're doing a weighing test, which I believe is what the court is likely going to do here, the harassment, the annoyance, the safety issues, the cause for an embarrassment greatly outweighs any potential probative value of Mr. Pemberton's testimony based on what's already been admitted. We already answered interrogatories early on in this case. We answered requests for admission early on. We produced all of the documents in our possession or his possession. There's nothing more to do here on that issue.
And hey,
So
don't forget to serve that what you shared with him. He was saying he hadn't seen that before, so make sure to get that over to opposing counsel.
sure.
Okay. All right. Anything before I pivot back? Anything else on your end?
No, I mean, I have other medical records I can put on the screen, but essentially they're supposed to be given for an in-camera review. I don't even know that counsel technically is supposed to be seeing. The one I've shown is a court filing, so that's why I had no problem putting that on the screen. I have his discharge paperwork from January of 23 from Summit Ridge. I have notes from his psychiatrist. I can't share those with opposing counsel. Those are appropriate for an in-camera review. So
Yeah.
whether you want me to FedEx those to your chambers, I can do that. But I'm not going to put those on a public screen for obvious reasons.
Oh, nor should you, nor have I asked you to. And no, I don't need those at this point for this decision. I have enough context here. And this is not our first one of these, but they all require very nuanced solutions because, as I said earlier, it's a sliding scale. And I'm trying very hard to figure out where your client is on the sliding scale. And that, like I said, it's in our first rodeo with these, but they all require very, very individualized solutions. So, okay, anything else before I pivot back?
Yeah, the only other thing I'll add, and this is in one of the notes that I'm not putting on the screen, but my client was employed in the deli at Publix on the date of the accident. You can see in his psych records that he's no longer employed there and hasn't been for many months, and that his psychiatrist had ordered that he not return to work. So it's not like he's working a 9 to 5 job. It's nothing even close to that.
Okay. All right. Thank you for that.
Sure.
All right. Anything else? I'd like to hear again from the plaintiff. And I think she brought up a good point. I want to hear what you want to tell me, but I also want you to see if you can identify some specific factual points that you're seeking, Mr. Brush.
Sure, Your Honor. Sure, Your Honor. Basically, the main things we want are his testimony of what took place at the scene of the accident. And like I said, I have not seen this. This is the first I've seen of this dementia report. So I don't like yourself. I don't know how severe it is. For us, the timing's mighty convenient for the defense side, but at the same time, if the dementia was severe, obviously we wouldn't want to put him through anything that's unnecessary. So for the defense side, or sorry, for the plaintiff side, we're merely trying to gather all the facts, all the testimony we can from the defense that's relevant and material to my client's claim.
And
So
I respect that.
right, and so for our end, if a significant other could participate in the deposition, we're open to that. Like I said before, we're not trying to put the defendant through anything unnecessary to harm his medical condition. And if it comes out that he cannot continue the deposition, the plaintiffs will in no way force him to sit there through more questioning.
Mr. Billiers, I'm going to come back to you. He's raised a good question that got me thinking. The doctor, it's no longer on the screen, and I don't need you to put it back up, but the doctor that evaluated, or is it a psychiatrist, psychologist?
Yeah, I'm just my search online is that he's a psychiatrist out of Fayetteville. He works at Southern Behavioral.
Okay, so medical doctor, psychiatrist. I'd be curious as if to that doctor would be willing to opine as to whether or not he's capable of sitting for a deposition. That would be helpful information.
Maybe, and I'll tell you, the documents I've been getting from his family members, and it's because, as you can imagine, psychiatrists aren't just going to take a call.
Yes, okay.
So I could find out.
Yeah, I would be curious because obviously I want to make certain that plaintiff's counsel has the opportunity to get the information they need. And frankly, I think the information they have a right to includes whether or not the defendant is capable of answering these questions. I think your affidavit, from the doctor, starts that question, but I don't think it goes as far as it needs to give the court enough information to make that decision. So, okay. So that's it. Again, I do not have a solution yet. I just have some thoughts. And again, I think this is exactly why I get paid to do this job. Both of you have very reasonable positions. You've argued it well. You've briefed it well. My job is always easier when I have good lawyers doing a good job, and both of you have done very good jobs for your clients. And I just want to say what a pleasure it is to have good lawyers come to court. It's always really nice. So, do you all need anything else that you want me to factor in before I wrap this one up?
I don't think so. I think that if you're thinking of granting counsel's motion, then I would like time to see if I can get an affidavit from the psychiatrist. Like I said, my efforts, it's hard to get psychiatrists to respond for obvious reasons. They've got clients they're trying to protect, or patients they're trying to protect, and privacy issues. But if that's the way you're leaning, I would like time to do that, because I think I do not think this person should be sitting for a deposition.
Well, I'm going to ask you to do that either way, because obviously we've got a trial coming up as well. So that question needs to be answered, because we've got deposition question now. We're going to have a trial question later, because we're going to have to address the fact that he has the right to call the plaintiff for cross-examination. And we're gonna need to address that. So I need that question answered now so that we can make certain that the plaintiff has everything I can give them that they would normally have access to. And again, this is not our first one of these, but they always require very specific solutions. And plaintiff's counsel, I'm definitely gonna give you as much ability to get the answers that you can. And I agree that one of the questions that you have the right to answer is, what can the defendant actually do or not do regarding answering of questions? And we're gonna figure that answer out. But we're gonna do this a little bit slower and make certain that it's a nuanced decision. All right, so definitely start reaching out to the psychiatrist. I'm gonna mute y'all just for a minute and check in with Mr. Hope, see if I've missed anything. I'll be right back, okay?
Okay.
Okay, y'all ready to take some notes? All right, let's go back on record. All right, here's what we got. So I'm not going to conclude this hearing. Instead, I'm going to adjourn it and reset the second half of this hearing for August 18th at 9 a.m. Y'all can report virtually just like you have here. Ms. Billers, the burden's on you at this point, so here's what I need from you. I need an opinion from either that medical doctor of psychiatry or a medical doctor of psychiatry, stating an opinion as to whether or not he is capable of sitting for this deposition. And once I get that, I will then be able to make a more informed decision as to how to give plaintiff the ability to get the answers that they would normally just be able to get par for the course without us having this. And I just want both of y'all to hear me say that we're going to, very much try to walk a line that gives you both some of the protections you're looking for from the defense, but frankly make certain that the plaintiff in anticipating trial has the ability to get the information they need to make an informed trial strategy. So I'm going to put that back on the 18th. That's just a continuation. Again, do not drive to Spalding County. Just report virtually, just like this. And I very much need that decision. And I'll go ahead and tell you, if you want to talk to the psychiatrist, if the psychiatrist says, yeah, I think he could do it, Ms. Billers, I'll go ahead and tell you my follow-up question is going to be, well, is it possible to have the psychiatrist at the deposition as the referee, kind of in my place, where the psychiatrist would have the ability to go, and we're done. Because obviously, if I had time, that's what I would do. I would just sit in there until I've heard enough to make me convinced that he's not going to be able to do it. And so that's the other thing I'm looking for is a referee. If I put you all in the same, if the psychiatrist says, yeah, I think he could take a shot at it. Obviously, if he says emphatically no, that'll give me another pathway to explore. So, all right, does that make sense as to kind of how I'm framing this up and what I'm looking for from Ms. Billers?
Yes. Yes.
Okay.
Um,
Go ahead.
Are we going to get written notice of August 18th, or is this our notice?
This is your notice.
Okay. And then we've got deadlines in this case. Like, for example, we have, I believe, an August deadline for expert disclosures.
Yeah. Those are stayed.
We stayed. Okay.
Those are stayed because we really can't move forward until we have this answer for either of y'all. So I don't want the deadlines to come and go while y'all are trying to sort this out.
Sure. Okay.
So obviously I'm gonna give y'all more time at the end of this to just kind of finish everything, to get everything finished up. So, okay, does that address your concerns, Ms. Billers?
Yes.
All right. And Mr. Bernash, do you have any questions for me or concerns or anything else you want to put under my nose before we part ways?
Yes, Your Honor. Is there a way to guarantee that the psychiatrist is aware of the options available? So is there, what I mean when I say that, is there a way for him to be on notice that he can sit in as the referee, as you said, on a deposition, instead of just having, a blanket question of, can he sit? Could he sit under certain circumstances? Is there a way that the plaintiff could be ensured that that's being presented to the psychiatrist as an option?
Ms. Billers, in communicating that to the psychiatrist, will you please put that in writing and provide that explanation that you're going to give to the psychiatrist to opposing counsel?
Sure.
And that way they've got what you told them. Obviously, you talk to them on the phone line. That way there's something in writing that they'll exchange. That'd be great.
Yeah, I don't think I'm going to be able to get this guy on the phone, but I'll put something in writing and send it and have, yeah.
Yeah, if he called you back, I didn't want you to feel like you couldn't take his call because I'm asking you to put something in writing. So
I gotcha. Okay.
Okay, does that address your concerns, Mr. Brown? Okay. Anything else, y'all?
Not from the plaintiff's counsel, Your Honor.
Okay. These cases like this that have mental health struggles, they are tough. And I just want y'all to know that I respect where both of y'all are coming from on this. I think both of you have valid points. You both need something that you can't do both. I can't give you both what you want, and I know that. And I just want y'all to hear me say that we will do everything we can to both protect the defendant's dignity while at the same time giving the plaintiff all of the access that they would normally have And I'm gonna work very hard to walk that line between the two of you. And either both of you will be mildly happy or both of you will be mildly disappointed. Either way, I'll have done my job. So, anyway, I just want y'all to know that we'll take this very seriously and we'll do everything we can to balance your both interests, because they're both valid. Y'all need anything else?
No, thank you, Your
Mayor,
Honor.
All right, we'll see y'all virtually on August 18th. And again, what I'm looking for at that point is something from the psychiatrist. It doesn't have to be a long opinion letter, just a very short opinion letter, but as to whether or not he can sit. If he says he can, would the psychiatrist be willing to be the referee in my place? And the psychiatrist wouldn't need to attend in person, they could be there virtually. Just say that out loud.
Okay. All right. Thank you, Your Honor.
All right, bye y'all.
Bye, counsel.
thank you, Your Honor.
Thank you. Okay, so that concludes the calendar. 22 SB 158, nobody was here on. The traverse is denied. We'll draw an order and file that. 22 SB 194, that's the one we just heard. That is reset to August 18th at 9 a.m. And then 22 SB 263 was dismissed without prejudice. And that concludes